Barack Obama signed a 5-year extension of the FISA Amendments Act of 2008, which established a legalized version of President Bush's warrantless wiretap program. It also granted the National Security Agency broad power to spy on Americans' communications with other countries without individual warrants. The law's supporters say it's only meant to target foreigners.
But we know that almost immediately after going into effect, the law led to large-scale collection of entirely domestic communications. We also recently learned that on at least one occasion, the secret Foreign Intelligence Surveillance Court found surveillance conducted under the law to have been unconstitutional. We don't know much else because nearly everything about the dragnet surveillance programs the law authorizes has been shrouded in secrecy. The reauthorization was rushed through the Senate just days after Christmas 2012, with almost no debate and very little media attention. But a small, bipartisan group of senators did attempt to offer a few reforms that would have provided additional safeguards for Americans.
Senator Jeff Merkley proposed that because the real scope of the law depends on how a secret court interprets it, the Attorney General should have to publish unclassified summaries of major rulings interpreting the law. Otherwise, we're effectively living under secret law because ordinary citizens can't know what the statute has been interpreted to mean.
Understanding how certain words are interpreted tells us where the line is drawn.
Senator Patrick Leahy proposed reauthorizing the law for just 3 years, so any debate and some accountability will come sooner, before the end of the Obama administration.
If we know we have to actually look at it because it's going to run out, you know what happens is an amazing thing. Senators actually look at it.
Senator Ron Wyden had 2 ideas. First, if the law is really supposed to be about targeting foreigners rather than Americans, the NSA should have to release estimates it makes of just how many citizens have had their calls and emails sucked up by the spy agency's vacuum cleaner, so we can determine if that's really true.
You can't even get a rough estimate of how many law-abiding Americans have had their communications swept up under this law?
The law's supporters say there's a secret reason they can't even provide a ballpark estimate, but ordinary Americans can't know what that reason is.
I'd like to just show that classified letter, if I might. It's classified, I can't read it to you. I don't happen to have it here, but as soon as somebody brings it, I will wave it for a moment so that you see it.
Wyden also argued that if the law isn't supposed to be about spying on Americans, we should prohibit our spies from searching through the NSA's enormous database of calls and emails for a particular American's name unless they get a specific search warrant from a judge.
It is never okay for government officials to use a general warrant to deliberately invade the privacy of a law-abiding American.
Congress never intended for the intelligence community to have a huge database to sift through without first getting a regular probable cause warrant.
A proposal from Senators Rand Paul and Mike Lee was simple but by far the most sweeping. It effectively eliminates the so-called third-party doctrine and requires that any government request for Americans' data be accompanied by a warrant. That's even if those communications are held by third parties like your email provider or web host.
The government must get a warrant to look and read your mail, and since the case Katz versus the United States, the government has been required to have a warrant to tap your phone. However, under current law, your email, your text messages, and other electronic communications do not receive the same level of protection as your phone calls do.
By means of these so-called backdoor searches, the government may conduct significant warrantless surveillance of American persons.
All of these amendments were defeated. The law's supporters say there just wasn't time to make changes to the law and get the House of Representatives to approve them before the law was set to expire at the end of the year.
The problem is we have 4 days.
But that's only because they refused to schedule a debate until the last minute.
This is likely to be the only floor debate that the Senate has on this law, encompassing literally a 9-year period from 2008 to 2017.
Our intelligence agencies need to be able to spy on foreign agents and terrorists in order to keep us safe. And even without this law, they've always been able to spy on totally foreign communications without court approval. But when they start recording Americans' communications, they should have to seek a specific search warrant from a judge. That's a requirement we imposed with good reason after discovering their long, ugly history of abusing their intelligence powers for illegal political purposes. With this law, we've effectively done away with that requirement. In theory, the government can intercept all of the phone and internet traffic coming in and out of the country and store it indefinitely. Does keeping us safe really require that much power? The government says, just trust us and stop asking questions. And it seems that Congress is unfortunately only too happy to oblige.